Thank you for being with us today for the first of the National Conference of Bankruptcy Judges, NCBJ consumer webinars for this year. I wanted to introduce Veronica Brown Mosley, who is moderating this panel today and will be introducing the speakers. Veronica is a shareholder in the Bowman Law Firm in Virginia and is a former NCBJ Blackshear Scholarship awardee. And so I think she's an alumni of the Blackshear. So we're delighted to have her with us. So Veronica.
Thank you so much, Your Honor. Hello, everyone, and thank you all so much for joining us. Welcome to NCBJ's Consumer Case Law Update. Today, 3 distinguished judges will provide us with insights on some very important consumer bankruptcy matters. I will begin with brief introductions of our esteemed panelists. Judge Brown retired in 2006 as a United States bankruptcy judge for the Western District of Tennessee. He served a 4-year term on the bankruptcy appellate panel for the Sixth Circuit from 1999 through 2002. Judge Brown earned his law degree from University of Tennessee College of Law. Judge Lynch was sworn in as a United States bankruptcy judge for the Western District of Washington, Tacoma Division on June 1st, 2010. He served as the chief bankruptcy judge of the district from October the 1st, 2014 to September the 30th, 2019. Prior to his appointment, he served as the standing Chapter 13 trustee for the Portland Division of the District of Oregon and as the standing Chapter 12 trustee for the District of Oregon. Judge Crawford was appointed to serve as a United States bankruptcy judge for the Northern District of Alabama on September 1st, 2016. He served as a Chapter 13 standing trustee at the Northern District of Alabama from 2004 until his appointment as a bankruptcy judge. Judge Crawford earned his JD from Cumberland School of Law at Samford University. To begin our program today, Judge Brown will provide us with an overview of some of the important cases reported in 2021. Next, Judge Lynch will share updates related to a debtor's right to dismiss a Chapter 13 case and conditioning dismissal. And last, but certainly not least, Judge Crawford will provide information on curing Chapter 13 plan defaults and modifications to cure post-petition mortgage defaults. The judges will be covering a great deal of information in the very short time that we have together today. So please review the materials for additional information regarding these topics. The materials will be prompted throughout the program and are also available at ncbj.org. Be sure to take a look. You're welcome to ask questions in the question and answer function throughout the program. At the end, the judges will answer as many questions as the time permits. Thank you again for joining us today, and I will now turn it over to Judge Brown to take us behind the bench.
Thank you very much, and I'm delighted to be with all of you today, especially to be with the rest of the panelists. We've all known each other a long time. We may have some comments as each of us are talking, ask some questions of each other. So the materials are being shared with you, but also they're available in the through the NCBJ website if you have not yet downloaded those. So in my materials, which represent some selected cases from 2021, I'll refer you to case names and to page numbers to help you move along with those. And starting really on the second page with the automatic stay, you're all familiar, of course, with the Fulton decision by the Supreme Court, came out of the Seventh Circuit, having to do, it arose out of that situation where the city of Chicago liked to seize cars and did not return them when debtors were filing Chapter 13 bankruptcies. The Supreme Court took a hard look at Section 362A3. That's the subsection that deals with exercising an act that exercises control over property of the bankruptcy estate. And basically, the Supreme Court said, maintaining the status quo by the city continuing to retain possession of those vehicles that had been seized pre-bankruptcy was not a quote act and therefore did not violate the automatic stay. Obviously, there'd been a lot of case law going in the other direction. So that's a tremendous shift in the way courts will begin to look at that. And if you look down that same page at the Ninth Circuit, BAP had a decision applying the City of Chicago Fulton case to, again, determine whether an action, what looked like an action by a creditor was in fact an act or was maintaining the status quo. And in that case, the Stewart case, the creditor had maintained the status quo by refusing to release a garnishment. Again, there'd been a lot of case law on those kind of situations going the other way before the Fulton case. I think one of the interesting things that's going to happen is if you look back up on that same page at a couple of decisions, one, the Perriman case out of the, again, Ninth Circuit BAP. In the Perriman case, the question was whether or not a pre-petition cause of action, domestic relations cause of action, so common in consumer bankruptcies, is asking the state court to continue that cause of action, a violation of the automatic stay. And the BAP analyzed that from the standpoint, well, it's sort of like continuing a foreclosure action. It doesn't really change anything. It's maintaining the status quo so long as there's not some further substantive action by the creditor. But on the other hand, compare the decision recently, the Smith case out of the Eastern District of Tennessee, where the bankruptcy judge said, wait a minute, in this domestic relations action, continuing the civil contempt action that was pending in the state court did violate the stay. Now, why would there be a difference in that and in the BAP case? Well, one of the reasons may be that the underlying debt in the Smith case would have been dischargeable. It was a 523A15 debt, not a support debt. And that debt would have been dischargeable. So I suppose one way you can look at it is, why would the state court need to continue a civil contempt action over whether the debtor was paying a debt that could have been or would have been dischargeable in the Chapter 13 case? So the facts are going to be important in these cases. You need to look hard at whether or not there is in fact still a violation of the stay by a creditor continuing to do something or maintaining the status quo. So is it a status quo maintenance, or is it a violation? Is it an act that violates the stay?
Judge Brown, this is Sims. May
Sure.
I ask one question?
Sure.
Going back to the Fulton case, probably most of our listeners today, viewers today, have read up on Fulton. They're familiar with the facts of the case. But it's my understanding there may be a little percolation within the Sixth Circuit or at the Sixth Circuit level about comments relating to other claims that may be available under 362A. Can you address that a little bit? Is there anything out there that may still exist, claims that could exist, sort of outside on the perimeters of Fulton?
That's a very interesting point, because the Supreme Court specifically said we're only dealing with 362A3. We're not addressing the other subparts of 362A. Now, it's interesting that the BAP decision that I mentioned, that BAP decision that's on the bottom of page 2, the Stewart case, the BAP went on to say, oh, and by the way, we were also dealing with the 362A3, but we don't see any violations of any other subsections. Now, I don't think every court's going to look at it that way. In fact, one of the spinoff cases still pending in the bankruptcy court in Chicago from the Fulton decision, the city was making that same argument. Hey, there should be a dismissal of the cause of action filed by some debtors here. I think it was a reported class action, where the debtors were alleging violations of other 362A subsections. And the bankruptcy judge said, I've got to hear more facts and more evidence in this case before I can rule. I'm not going to grant a dismissal. There may be violations of other subsections. And so I think you're absolutely right, Judge. You're going to have to debtors are going to have to look at whether or not there are other subsections that might be violated. Jump over to page 4 under the property of the estate exemptions heading and look at that Wheatley case out of the Northern District of Illinois. I mention this because I've always had for a long time a lot of interest in exemptions. And this is one of the few cases I've ever seen recently, especially, that took a look at what does the code section mean. The code section now 522B3 Part B that refers to a debtor being able to exempt tenancy by entirety or tenants in common interest under applicable non-bankruptcy law. What does that phrase applicable non-bankruptcy law mean? Well, here in this case, the Chapter 7 debtor lived in Chicago, claimed some exemptions under Illinois, but he also claimed an exemption in tenancy by entirety in a condominium located in another state, Michigan. And the trustee argued, well, the debtor can't do that. The debtor can't claim tenancy by entirety exemption in something located in another state when he lives in Illinois. And the court said, no, that phrase, applicable non-bankruptcy law, refers to where is the property located that the debtor is claiming a tenancy by entirety exemption in. And the law in Michigan did not require that the tenancy entirety exemption be in homestead property. This was not homestead property. So it's an interesting decision to take a look at from the standpoint of meaning of a particular phrase in the bankruptcy code. Now, if you look over at page 6, dealing with exemptions again, the 4 circuit decisions you need to be aware of dealing with the conflict between exemptions and set off. The 4th Circuit had a prior decision in 2000, the Copley case, and then they had a follow-up decision, Wood, this past year. And basically these decisions emphasize that set off by the government, especially for tax claims, are protected under 522 Part C because those tax claims survive the bankruptcy and the exemptions. And furthermore, the government has specific set-off rights under IRS code and other sections to deal with debts owed to government entities. And so basically the set-off right prevailed over, the government set-off right prevailed over the exemption rights of the debtor. Now, jump down to on page 7, the Castleman case. I just want to mention dealing with, this is where a lot of case law is developing now on what happens to property of the estate upon conversion. And we'll hear more about this later on today. And there is also later on this year another NCBJ webinar on that general broad topic. Look at page 10 at the a couple of decisions dealing with the student loan issues. First, you're all aware that the 2nd Circuit reaffirmed Bruner as the standard for determining undue hardship. And you all know that's a pretty harsh standard, making it typically very difficult to prove undue hardship. And the 2nd Circuit denied an opportunity to take another look at that. Right below that, another 2nd Circuit decision, the Hamiden Sally Mae case. I think this is where a lot of the case law, or litigation rather, is been going recently about student loans, is not trying to prove necessarily undue hardship, but trying to establish whether or not a particular obligation is covered at all by 523A8. And here in particular, it was one of those obligations that was to repay funds received as an educational benefit, scholarship, or stipend under 523A8 Part A little II, what we typically think is referring to private student loan obligations. So my point is, you need to take a hard look at whether or not there is a particular obligation is even covered by 523A8. Then if you look at on page 10 and 11, starting on the bottom of page 10, I think another direction that the student loan litigation is going is partial discharge. Now, I recognize a lot of you are in districts that don't recognize the ability of the bankruptcy court to grant a partial discharge. Sometimes courts don't express it in terms of partial discharge, but say one particular debt is dischargeable while other particular debts are not dischargeable under the undue hardship standard. But it's a very interesting decision that if you're looking at this and seeing if you can apply it, look at the Randall decision out of the bankruptcy court in the District of Maryland that did decide that it could grant a partial discharge. That, in other words, the debtor showed undue hardship to pay some of the debt. And the court went on to set how much of the overall debt would be repaid and over what period of time and at what interest rate. So take a hard look at that possibility if you're litigating undue hardship. Then look on page 12 at the Golden case. I mentioned this at the very top of the discharge injunction. I mention this because you have some litigation now on whether or not the bankruptcy court has authority, has jurisdiction to hear discharge injunction violations across the country in other districts other than my own. The Fifth Circuit not long ago had a decision that said that the bankruptcy court could only determine a discharge injunction in a case in that court, not a nationwide case. Well, the Golden case, and then flipping over to the bottom of page 12 and 13, another decision out of also the same court, the Eastern District of New York, said, wait a minute, I do have authority to hear this discharge injunction, even though it involves discharge from other courts, because it is a bankruptcy code discharge injunction, not the court's individual order that's at issue. And then I wanted to mention what I think is a very important decision on page 14, the Rhodes case dealing with reaffirmation. This is a decision out of the Southern District of California late last year. We all thought, and you may think that ride-through, the choice of ride-through was done away with by the 2005 Act. And I probably have said that myself before in seminars. This court points out that's not necessarily true. If the debtor in the Rhodes case entered into a reaffirmation agreement, Chapter 7 debtor, the debtor's lawyer signed off on the reaffirmation, certified it as the code requires, but did it under threat from the creditor, where the creditor basically was saying, if you don't certify this reaffirmation, we are going to repossess the car. And so the debtor signs off on it, or the attorney signs off on it. Then in the hearing the court had, the debtor withdraws that certification. So essentially the reaffirmation became unenforceable. But the court went through an analysis of the debtor had complied with the requirements for reaffirmation, had required with the requirements under Section 521, mentioned in the materials here, and 362, and therefore the debtor was protected essentially through ride-through, where as long as the debtor continued to make the payments on the secured claim, the creditor would not be permitted under applicable state law to repossess the vehicle. So my point is, guess what? Ride-through may still exist. It doesn't mean it's easy to do, but what this case points out is reaffirmations themselves are not always easy. My time is running out here that I wanted to reserve to this, but let me jump over and mention, obviously on page 21 and 22, a very important decision out of the Second Circuit also, and that deals with Rule 3002.1 and damages and sanctions. The Second Circuit in the Gravel decision late last year said that Rule 3002.1 did not provide authority for the bankruptcy court to issue sanctions for violations of that rule. And in particular, in that case, they applied the Taggart standard, which was a discharge injunction case, not a Rule 3002.1 case. And that's a very important decision. There was a motion for en banc review or reconsideration that was denied. So that is the law in the Second Circuit. But I wanted to mention the Lagarde Doctor case recent case from the District of South Carolina Bankruptcy Court that took a hard look at what remedies are available when a creditor violates Rule 3002.1 and reminds us that the remedies include you can't assert those undisclosed post-petition fees, in this case, taxes and insurance, as a grounds for default during the bankruptcy case. And you can't ask for stay relief. You can't ask for denial of confirmation based upon the fact that you failed to the creditor to disclose what the Rule 3002.1 requires. So there are still remedies, the bankruptcy court points out, for violating that rule. All right. I know there are going to be questions. I hope so. And take a look at the materials, and let's move now to Judge Lynch.
Thank you, Bill. Hopefully you'll look at those materials. Judge Brown's always been very generous with providing these materials. They're excellent materials. It's a really good summary of what's gone on in particularly consumer bankruptcy in the last year. I'm going to cover a particular topic which, for whatever reason, has become a very, has had a lot of decisions in 2021. It has to do with the right to dismiss and the corollary issue with the right to dismiss, which is if the debtor has a right to dismiss in Chapter 13 under 1307B, what possible sanctions can a court impose to a bad faith filer? 1307B, to remind everyone, says on request of the debtor at any time, if the case hasn't been converted from Chapter 7 or 11 or 12, the court shall dismiss a case under this chapter. And we've had some developments on the Supreme Court level involving cases which had nothing to do with the right to dismiss in a Chapter 13, but which have changed the landscape in Chapter 13 dismissals. The first case was Marama, which time has flown. It was a 2007 case involving a right to convert a case from 7 to 13 under 706. And the court held that that right was not absolute when the debtor was in bad faith, and the court had authority to prevent an abusive process. Marama came down, a number of cases looked at it and said, well, that should apply also in the case of a motion to dismiss under 1307B. And so we have cases, including a case out of the Ninth Circuit called Rawson, which held that the right to dismiss under 1307B, notwithstanding the language of that statute, is not absolute. Well, then along came in 2014 the Law versus Siegel case, another Supreme Court case, another case that had nothing to do with dismissal or Chapter 13, had to do with surcharging exemptions. And the court held that the bankruptcy court improperly surcharged an exemption for bad conduct, bad faith conduct by the debtor, because there was no inherent, that it exceeded its statutory and inherent sanction powers, where the federal law provides no authority for the bankruptcy court to deny an exemption on a ground not specified in the bankruptcy code. So Law versus Siegel comes out, and then there's been a change, not just in that surcharges, but in other areas. And a lot of commentators said, well, after Law versus Siegel, Marama and Rawson are in jeopardy. Marama was a 5-4 case. Law versus Siegel was a 9-0 decision. And lo and behold, we had two decisions come out this year in the 6th Circuit and the 9th Circuit. One is the Smith case in the 6th Circuit and the Nichols case in the 9th Circuit, where the court, as anticipated by the commentators, held that the right to dismiss under 1307B is absolute. And the court doesn't have the power to somehow stop that because of bad conduct or abusive process by the debtor. The Ninth Circuit explicitly overruled the Rawson case. I was wondering if there's any takeaways that my fellow judges saw out of these decisions.
You know, Judge, it's occurred to me, not just through the cases you've mentioned, but several other decisions on the lower level, that Law versus Siegel has just had a tremendous impact, where courts have begun to, appellate courts perhaps especially, but bankruptcy courts as well, to question their authority to do certain things because of that edict from Law versus Siegel that your equity power can't violate what the code specifically says.
Right.
That really was nothing new, but it does seem like a lot of courts have. I see more and more citations of Law versus Siegel,
Particularly in the exemption area, but even obviously in areas like this. Yeah. For me, the lesson is if you're a debtor and you want a case dismissed, you need to file your motion under 1307B. You don't want to leave it to a motion by a trustee or a creditor where the court has the discretion to convert or dismiss this case. So much these days we see increases in values which are exceeding exemptions in many states, and you don't want to get caught and with the problem of appreciation and who gets the appreciation in a piece of property in a Chapter 7, with Chapter 7 trustees who are like so many of us looking for cases to work on.
Let's suppose, Judge, that a creditor does jump in first and move to convert the case and start citing bad faith and other things. Can the debtor just come back with the response of, wait a minute, here's my motion to dismiss, and you've got to grant it?
Yes. The simple answer is after these decisions, after Law versus Siegel and the Smith and the Nichols cases, I think that's what you should do if you're a debtor's attorney, particularly if you're afraid that this case is going to get converted, which is often what the creditor wants, thinking that trustee will liquidate the asset and pay something to the creditor. So yes, I think so.
Judge Lynch, this is Sim. So one follow-up question based on Judge Brown's comment then. If in the Ninth Circuit or in the Sixth Circuit, there is an absolute right for dismissal, what if there is no motion to convert pending by a creditor or by the Chapter 13 trustee? Is there all of a sudden, is there some new option for the bankruptcy court, whether it be sua sponte or based on something in the record, to consider conversion, even though all that's pending now is this absolute motion to dismiss based on a right that the debtor has in a couple of circuits?
Well, I don't know the answer to that question. That's an interesting question about how much authority the bankruptcy judge has to sua sponte convert a case. But if I was a debtor, I would never, a debtor's attorney, I would never let myself get caught in that question. I had a case very recently where the creditor was moving and trying to get the case converted, and I pointed out to the debtor's attorney, who I had not responded the way I thought they might want to, that they might want to take a look at these cases that had come out and decide what they want to do before I rule on the motion by the creditor, which was really asking for conversion of the case. So I'd say, rather than hope that the judge will exercise discretion and dismiss the case, or as opposed to converting it, if I was the debtor's attorney, I would be taking the bull by the horns.
And I'm sure that our moderator, Veronica, is saying, no, you can't do it. Move on and dismiss the case, right?
Well, if you file the motion, after these cases, and I really think, the only cases that still say there's no absolute right to dismiss are pre-Law versus Siegel cases. All the post-Law versus Siegel cases, at least at the circuit level, and the ones that I'm aware of, have held that the right to dismiss under 1307B is absolute.
Well, at Judge Lynch, I know you're about to go there, but okay, so the debtor is moved to dismiss, the creditor jumps in and says, oh, no, you should convert the case. Do you have an option of saying, well, there's something else I can do here? I've got to dismiss it, but what about conditions?
Yeah, and there has been law on that area this year, which I want to talk about. Obviously, there's Section 109G, which is says that if a case is dismissed for violation of a court order or failure to appear before the court, the debtor is not eligible to file for 180 days from dismissal. The good news is that's self-executing. So the issue doesn't really come up typically at the time of the first motion to dismiss. It comes up when they refile. But the bad news is from a creditor perspective or a trustee perspective, the party arguing that the dismissal the arguing for dismissal must show that there was a willful failure to abide by a court order, which creates a whole new factual question sometimes. The section that's really getting a lot of attention is Section 349A. And it's to remind people, 349A provides that a dismissal prior to discharge is without prejudice to obtaining a discharge of the debts in a subsequent case. Well, that's good news for the debtor, but there's a preamble that says, unless the court for cause orders otherwise. And the recent cases have looked at 349A and looked at whether there is cause that would allow a court to sanction a debtor. There's the Smith case, which I referenced with respect to dismissal, said that the court had certain inherent authorities to sanction the debtor for bad faith. And that might become a basis for some sort of sanction order. The Minogue case out of South Carolina, in my materials, Judge Waits had a situation where the debtor asserted an absolute right to dismiss, and the court found that it had authority to issue remedial orders to address a debtor's bad faith or abusive process under 349A. And he approved an agreed order that had a 2-year bar to refiling. And there's another case, Parsons in Texas. But the case I wanted to talk about, and I think it's an excellent case. It's Judge Klein, typically incisive and thorough. I call him the honcho of the head notes. I think there's 48 or 49 head notes, and that's not in Judge Klein's world. That's just small potatoes. But he does an excellent job and talking about 349A in the context of 1307B. He points out that regardless, 349A triggers an issue about whether or not the dismissal is with prejudice or not, regardless of the fact that there's a 1307B motion. Doesn't matter whether it's 1307B or 1307C or some other theory for dismissal. It touches on a number of issues regarding the interplay between those two sections. Not only is 1307B does not immunize the debtor from consequences of dismissal with prejudice, it leaves the court for another day, by suggestion from Judge Klein, to look at circumstances that may warrant raising the 349A issue even after dismissal. Now, he doesn't decide whether you have to talk about your retaining that power or issuing sanctions in the context of a dismissal order, but because it's not the issue before him, but it's a really important part of this issue. He talks about bad faith in the context of 349A being a much higher standard than a standard for bad faith in a 1307C type motion. It really requires egregious behavior by the debtor. The burden of proof in good faith or bad faith in the context of plan confirmation is typically on the debtor, but the burden of proof at this on 349A is on the creditor or the moving party. It definitely requires a hearing, a due process type hearing where you give the debtor notice you're contemplating a sanction like a bar, and so that the debtor has because you're effectively denying a discharge to this debtor, so you have to have a due process hearing. He talks about the meaning of with prejudice in the context of 349A, and he talks about weak and strong form orders. Weak meaning a temporary bar as opposed to a strong form dismissal with prejudice in 349A, which would be lifetime. And just because he's Judge Klein, he also gives you a footnote about the word absquatulate, which you just have to, I'm going to recommend you read. I actually recommend this decision for a number of reasons. It's on appeal, so there's going to be further developments, but I do think it's a really helpful decision in terms of what kind of sanction powers we retain when we're going to dismiss the case, even if it's under 13.7b.
This is Sims. One other question based on your comments. So in Duran, maybe we're dealing with a situation where a creditor moves for dismissal and in the motion cites a basis for barring the debtor from refiling for a period of time, or a trustee moves with a similar motion. What about, I know at least in this court, almost every week, there will be just what appears to be a vanilla motion to dismiss by a debtor. And if you go under the theory in the 6th or the 9th Circuit that it's an automatic right, debtor just wants the Chapter 13 case dismissed for whatever reason. With that type of standard motion, which I imagine our viewers, whether you represent debtors or creditors, see frequently, is there automatically, does notice need to go out an opportunity for hearing if the court is considering some sort of bar on just your standard debtor wants to dismiss case? We're going to move on the dismissal, but I'm going to institute a 3-month bar to refiling, or any bar to refiling. Or if the court is going to consider that with a standard motion to dismiss by the debtor, is that one where the court could include the bar provisions without providing notice and an opportunity for hearing?
I read Duran, and I think Duran is right. No, if you're going to do a bar, you got to give notice, whether it's in the motion that the party that's seeking dismissal wants, or if you sua sponte want to do that. And the real tough question is, I think it's pretty clear we have jurisdiction to look at cases even after they're dismissed. I mean, we do that all the time in automatic stay damages claims. But the question is going to be, do you need to, when you dismiss a case, if you haven't given notice, do you need to put something in your order that retains jurisdiction to look at the bar? If you think that there's a potential for entry of a bar type ruling, you probably, if you're not going to put the matter over and have a hearing at the time of dismissal about bar, then the next thing you need to do, I think, to avoid the argument that somehow you didn't retain that right to issue a bar after dismissal, you should probably include that in your dismissal language.
Judge Lynch, I know we don't want to invade further on Judge Crawford's time, but this does seem to lead to a question I saw from the audience, and that is, can the bankruptcy judge delay granting the debtor's motion? So the debtor files a motion to dismiss. Nothing's filed in response. So the judge, for whatever reason, says, I think I'll sit on this a week or two and see what happens. Or since it's an automatic right to dismiss, at least in your circuit and mine, doesn't that mean you got to grant it?
I think that's a really good argument. Although typically it's not made by the debtor, they're usually happy to have me stall off a motion to dismiss. But to the if they have some reason why they need to get the case dismissed, it's a voluntary chapter, and I think I would tell them, okay, I'll give you a dismissal order, but I'm also going to retain jurisdiction to consider whether to bar you from filing, and might even set a hearing in my order of dismissals on the bar. Thank you, Bill.
Right.
Browns. So we go on to Judge Crawford.
Sounds good to me, Judge Lynch. Unless Judge Brown has anything further to add, we'll get started on the last group of cases. First of all, let me thank the NCBJ for inviting Judge Brown, Judge Lynch, and myself to speak today. We're very glad to be with you, and thank all of you for attending. It's just good to be here. It really is on a Friday morning. So the topic that I'll be covering today concerns curing Chapter 13 plan defaults, modifications, which certainly, at least in my court, has been a popular topic, a popular issue as we negotiate through the pandemic where we are all over the nation. And so I want to start with that from the written materials, subsection A, about the CARES Act and the COVID Relief Extension Act as well. So a lot of you are probably aware that there were a few provisions of the CARES Act that did lapse late last year, December 27th. And those aren't really what I'm focusing on so much as what did not lapse. So under the Extension Act, a few of the provisions that are relevant to us in our world, our bankruptcy world, were extended to March 27th of 2022. And the main one that's relevant to our talk today deals with Chapter 13 debtors and their ability to seek to modify a plan if two things are met. Number one, if the plan was confirmed before March 27th of 2021, that's part of the extension, and the debtor is still experiencing COVID related hardship. So if those two elements are met, then under the extension, your client has the ability to seek extension up to 7 years on the plan term. So that's still there under the Extension Act. So don't give up completely if you represent debtors on the CARES Act, because some of the provisions, the ones that I think have the most weight to them, are still available through March 27th. Two takeaways on that. Remember, the plan has to be confirmed before March 27th of 2021 in order for that extension to be applicable. Number two, the other takeaway is, I guess it's possible that Congress could seek an extension of the CARES Act beyond the March 27th, 2022 date, probably for your interests in representing your client. You want to go with what the law says now as opposed to what potentially could change with legislation in the future. And what we do know now is that those provisions have been extended. And to that extent, that's why I cited the Albert case, which is from Judge McNamara. The site is there for you out of the District of Colorado. It's a really thorough opinion that grapples with these type issues. When you've got a debtor, in this particular instance, Mr. Albert, who defaulted on a plan payment in the last month of a 5-year plan. And Judge McNamara went through and discussed Kinney and the impact in the 10th Circuit that has when a debtor doesn't complete the plan within the 5 years, and the negative implications for the debtor's ability to get a discharge under Kinney when that happens. Judge McNamara also discusses the Class case from the 3rd Circuit that runs along the same lines about denial of a discharge if the plan is not completed within the 5-year period of time. But so if you're looking for a decision that addresses this when your client is right at the end of a plan and defaults on a plan provision, or possibly is just after the 5 years, what can the court do? What does the court do in Albert? The answer is that Judge McNamara walked through, and with consideration of the CARES Act and potential for modification under Section 1329, extended the plan for a short period of time, not the full 84 months, right? But a short period of time so that the debtor could in fact complete the plan and be eligible for a discharge. So some provisions there you want to be aware of. And the most important one of which is under the extension of the CARES Act, March 27th, 2022 is the new sunset provision on certain provisions. But again, the takeaway there, the plan must have been confirmed before March 27th, 2021.
Judge
We're limited on
Crawford.
time, so yes,
Judge
Judge Brown.
Crawford, you mentioned, of course, the Kinney case, and I ran out of time to talk about it. It's cited in my materials by way 10th Circuit case on page 19, I think. Wow, what a strong decision, harsh in many people's view, that said 5 years is it. You know, so if a debtor, as you were talking about, of course, I know the CARES Act provision changed Kinney in one sense, but if you're just dealing with a normal case not trying to prove CARES impacts. Basically, what Kenny said is when the 5 years is up, you cannot extend the plan, I guess, even a month or two to cure defaults, right?
Judge Brown, I think that's the proper analysis of the Kinney decision in the 10th Circuit. I think that's
Yeah.
binding precedent, and it says what it says. CARES Act, I agree. I think that's a different wrinkle, as Judge McNamara wrote to in the Albert case. And that's a good resource to look at that, again, with those two conditions from where we sit today, Judge Brown. Was the plan confirmed before March 27th of last year? And is the debtor still experiencing a COVID-related hardship? And if those two elements come into play, there may be some wiggle room there, as Judge McNamara ruled. But Kinney is still there. Class is still there for those two circuits.
And I know there's some case law outside of the 10th Circuit dealing with that 5-year cap. And you know, we used to be accused in Memphis years ago when I was on the bench of cases going on forever, but that wasn't true. But but the point is, if you're outside of the 10th Circuit and you don't have that kind of authority, you certainly still might argue the debtor should have another month or two or some short period of time to cure defaults during the plan. But Kenny's going to come up to bite you, no doubt. People are resisting that motion.
Judge Lynch?
Yeah, I find Kinney, I understand the statutory reading, but I also understand that other appellate courts have read the same language and said, come out the other way. It is an extraordinarily harsh decision. This woman made all her plan payments and all her mortgage payments for all her plan payments for the 60 months, all her mortgage payments for 56 months. Defaults in the last few months, after 60 months, catches it up within 2 months, and she's denied a discharge.
Yeah.
That is shocking. I mean, ever since BAPSIPA was passed, you know, under pre-BAPSIPA, 36 months was the normal length of the plan, and you had an extra 24 months if you needed it to cure a default or pay some obligation. You don't have that if you're above median, and you've got to, so you got to somehow, if you're the debtor's attorney, hopefully catch this problem early enough so you can modify the plan. And I think there's ways to manipulate the arrearage and pay the arrearage through the plan. But when it happens like this, what are your choices? I mean, and oftentimes in my jurisdiction, the extra months are to pay the debtor's attorney. And it puts everybody in a quandary. So I'm going to deny the discharge because the debtor's attorney's fees haven't been fully paid. So I found that decision impractical, I guess, is probably.
Well, it's as you said, harsh, but it's the reality in the 10th Circuit, and other courts, you know, certainly could feed off of that decision and do the same thing.
We could talk an entire hour about that particular provision, but we have limited time. So let me cover a few more cases that I think our viewers will find useful and interesting. The next one is the In re Smith case. That's from Judge Posluszny in the District of New Jersey, bankruptcy judge. And in that particular case, again, another case related to COVID-19, where the debtor lost his income because his business just came to a near standstill, and he was only receiving unemployment benefits. On his job, it was a joint case, a husband and a wife. He defaulted for the third time on mortgage payments. And as a result of that, he moved to modify the plan under the CARES Act, extend the plan term to 73 months, and the mortgagee objected. So the issue here was, can the debtor modify the plan to include this post-petition default within the plan to cure it before the end of the modified plan term? Ultimately, Judge Posluszny said yes, the debtors were eligible for CARES Act relief in this particular case, and they were eligible to modify the plan under Section 1329. And equally as important, Judge Posluszny held that, look, this is not a violation of the anti-modification provisions of Section 1322B2. We're not going that far. So it's not modifying the mortgage. It's addressing a post-petition default as permitted. And in Judge Posluszny's case, he was persuaded by the Hoggle decision out of the 11th Circuit, which all of you 11th Circuit practitioners are familiar with. It was a case from 94, as well as the Mendoza decision, another case from the 90s that is binding in the Fifth Circuit. And so he authorized by his order the debtor's permission to cure that post-petition mortgage arrearage, and followed the plain meaning of Section 1322 to say that underlying all of this are Chapter 13 principles that provide for flexible repayment plans and give homeowners continuing rights to cure defaults so that they can preserve their assets. So the takeaway here, for those of you not located within the Fifth or the 11th Circuit, is you now have a fairly new case, brand new case, that's persuasive authority for an argument the debtor can cure a post-petition default on a mortgage within the confines of a Chapter 13 plan without violating the anti-modification provisions of Section 1322. Good case to take a look at. Another wrinkle on post-petition and post-confirmation plan modification. What about a post-petition personal injury settlement? Settlements, even during the pandemic, still continue. They may have slowed down for a short period of time, but at least in this region of the country, settlements continue to roll in with notice to the bankruptcy court, the bankruptcy trustees, and creditors in cases. And In re Taylor is one such case that Chief Judge Summers decided very recently in the bankruptcy court for the District of Kansas. That involved Jan Hamilton, the trustee in Topeka. You may remember Jan from his days in the Lanning case before the Supreme Court. But in this particular case, the debtor had a post-petition injury and a post-petition settlement. I think that's key. So tuck that fact away for a few minutes. And it was a large settlement, almost $300,000. And Jan, as the trustee, said, wait a minute, motion for turnover, move to modify the plan. That money needs to come into the estate. That was the issue on this post-petition cause of action. And in this one, it happened to be post-confirmation as well. Was that property of the estate? Did it need to come into the plan for a modification under 1329A? Chief Judge Summers held no. The settlement was not property of the estate, and his analysis went down the track of the best interests of the creditors test under 1325A4. And his rationale here, he did a really good analysis of the differences in the estate property under 541 and under 1306. And he ended up following the Barbosa case, which is a First Circuit case from 2000. And he also followed the opinions of two retired Kansas judges, Judge Nugent and Judge Carlin. And what he did was applied the effective date for the best interest test was the date of the modified plan, not the date of the original plan or the original petition date. And you're thinking, well, Crawford, why do we care? Why does that matter? Well, it makes a big difference here. Under Judge Summers, Chief Judge Summers' reasoning, he went down the road of Section 348F, not Section 1306, to determine what property was property of the estate for that hypothetical Chapter 7 liquidation test. And it makes a big difference here. So the takeaway here in this case is that you have to look, this one stands for the proposition that you go with the plan modification date, not the petition date, in determining what property is in the estate. And 348 is a tricky section that gets into what happens in a Chapter 7 case when you're dealing with property of the estate or post-petition property for which the Chapter 7 trustee can't chase. And it really made a $300,000 difference in this case for the estate. Good resource for you if you're ever presented, if your client is presented with these type issues. Moving right along. Next case worth mentioning in the brief minutes we have, In re Burnstead. This is on plan modification with a vehicle surrender. In this particular case, it was a 910 claim, which means, I'm sure everybody knows, a car bought within 910 days of the petition date. Plan was modified, and in the 11th Circuit under the Barrett case and under the Brown case, and now under this opinion as well from Judge Coleman, the Burnstead case, the debtor can surrender post-confirmation a vehicle, not consistent with the 6th Circuit Nolan opinion, but it is consistent with Barrett and Brown in the 11th Circuit, and was able to surrender the vehicle, but And the but here is that the creditor is entitled to a deficiency unsecured claim after disposition of the collateral. And I think that's the takeaway for you, unless you're in the Sixth Circuit. For any other circuit, including the 11th Circuit, the takeaway here is surrender is possible post-confirmation, but the creditor still gets an unsecured deficiency claim after disposition of the collateral. Whereas under Nolan, once that secured claim, once the plan is confirmed with a secured claim, it stays confirmed. Can't come in and flip it so that the creditor gets an unsecured deficiency claim rather than a secured claim. And again, the circuit case law here, when you're talking about, I think an important point, and I'll turn it back over to Veronica, is that if you're dealing with a 910 vehicle, a 910 claim, the hanging paragraph, which is located after the end of section 1325A9, after A9, when it knocks out section 506, if you're dealing with a 910 claim in this type of scenario, what that means is the parties revert back to their contract rights. They don't revert to, or they don't go to a zero claim for the creditor. It doesn't eliminate or disallow the claim. They go back to their contract rights. That's what Judge Coleman held, and that was his interpretation of both Barrett and I think Brown as well within the 11th Circuit. So that's my story, and I'm sticking to it, Veronica. Having said that, I want to turn it back over to you since we're short on time.
Yes, thank you so much. So we are short on time. Unfortunately, we won't be able to have the judges answer all of the questions that have been presented. But one question that an attendee inquired about, whether the judges may be willing to speak about the split of authority regarding whether the automatic stay under 362 C3A ends as to the debtor and the debtor's property, but not as to property of the estate. And this question did relate to the First Financial Bank v. Clark decision on page 3 of Judge Brown's materials.
Yeah, and let me just say, Veronica, it's a great question, and there is obviously a lot of conflicting case law out there on this, including some circuit authority. But I just say to you, look at the Clark opinion that is on page 3 of my materials. It has a good discussion of the split of authority, identifies that split. This is a district judge, by the way, in the Clark case that said, I'm going to go with what I see as the majority view, that when the stay is lifted under section 362 C3A, it's only as to the debtor and the debtor's property, not property of the estate. But say the judge explains and goes into some detailed discussion about the split of authority.
Thank you so much for that explanation, Your Honor. So just one other question. An attendee inquired about the relationship between the alleged stay violation in the Fulton case and a turnover injunction under 542. Would you be willing to briefly touch on that in the 1 minute we have left here?
Yeah, and everybody could certainly jump in on this. This is a great issue left undone, so to speak, by the Supreme Court in the Fulton decision. And in fact, you have that very strong opinion in that case by what Justice Sotomayor, that, hey, the turnover should be what really is the focus of debtors, and that the Rules Committee and the Congress should strengthen turnover. I think the bottom line takeaway from the Fulton decision is debtors still may have a strong turnover cause of action, but the issue is there's a split of practice around the country. Some people do that by adversary proceedings, some people do it by motion. Should there be a tweaking of the rules to make it clear? It could be by motion. All of those things are still on the table, but turnover is a separate issue from stay violation.
Thank you so much. And thank you so much to all of our judges for a great program today. And thank you again to our attendees for joining us. And I hope that everyone has a wonderful rest of the day and a great weekend.
Thank you, Veronica.
Thank you, Veronica.
Thank you.
Thanks, Veronica. Goodbye, everyone.
Thank you. Goodbye, everyone.